Welcome to Public Affairs Roundtable, a discussion of current events in the nation and around the world and how they affect the people of Indiana. Here's your moderator, Larry Lough.
Until recently, about all we knew about a federal judge named Robert Bork was that he had, under orders from President Richard Nixon, fired special White House Watergate prosecutor Archibald Cox over the objection of Indiana's own William Ruckelshaus, who had refused to do so. But now that he's been nominated for a seat on the U.S. Supreme Court, we're learning much more about Robert Bork. Is he indeed a brilliant, compassionate man, as his supporters say, or a biased, closed-minded judge that his detractors would have us believe? Today on Public Affairs Roundtable, we'll discuss Robert Bork and his nomination pending recommendation before the Senate Judiciary Committee. Hearings going on now. Our panel of experts include John Mull, who is an attorney with the Muncie firm of DeFur, Varan, Hanley, Radcliffe, and Reed; Ralph Baker, a member of the political science faculty at Ball State University; and John Rouse, our executive producer and also a member of the political science faculty. John, the media keeps referring to this confirmation process, the impending confirmation of Robert Bork, as perhaps having a sweeping and profound effect that will be felt in the courts in the nation for years. Is this an overstatement?
His articulate ability is raising very key issues in society. This being the 200th anniversary of the Constitution, he is raising questions about the proper role of the non-democratic branch in our system. The legislature and the executive are products of the majority. In other words, the people elect persons who hold those offices. Meanwhile, the courts are the non-elected branch. So his ability, his function, his importance is the fact that he is raising a very key agenda which will be decided at a later time. In other words, the courts may propose issues, but the people in the long run dispose. So the strength of what he's doing is that he is raising an agenda. And in that sense, he has much ability, and he is having a very great impact.
Do we have a court here, gentlemen, that one man, Robert Bork, whatever his ideology, will be able to have such an impact, will swing the balance? Are we on the edge, Ralph?
Yes, I think we are, because of really two reasons. One, Judge Bork is an activist. Activist in the sense that he would change policy. And so if you put an activist on the court, you always have that possibility. Then you have to look at the second factor, the context. And he is replacing a judge, Judge Powell, Justice Powell, who was on the winning side last year, 90% of the cases. This was a man that held the balance on a lot of key cases, voting with the conservatives on rights of the accused cases, pro-state, pro-prosecution. But on some very significant issues, he voted with the liberals. And so Judge Bork would fit into that opening, a context where there is a real potential of 4-4 splits on a lot of major issues, like abortion, like affirmative action, like the whole issue of privacy. And Justice Bork, just in numbers alone, plus his judicial activism, could be the key person. So I would say, yes, he does have that ability to change the whole drift of the court for some time.
Go ahead, John.
Let me respond to that a bit. It's important to remember, however, that you can't put a justice of the Supreme Court in a slot and say this is the way he or she is going to rule on a particular issue. Number one, they're limited by the facts and the cases that are presented to them and that they choose to hear. Secondly, you can't always predict the way a judge is going to rule or what his thinking is going to be down the road. For example, when President Kennedy appointed Whizzer White to the court, I doubt that he expected him to become part of the conservative bloc, which he clearly is. And when President Eisenhower appointed Judge Brennan to the court, who's the liberal spokesman for the court now, there was certainly no expectation that either he or Chief Justice Warren, who was a great leader of the liberal bloc of the court, would have taken those positions. I think their approaches to deciding cases were quite a bit different from what President Eisenhower would have expected.
John, I understand your point, but it seems that this judge, or this potential judge, is controversial because he is suggesting a change in the rules. If you look at changing the rules or rethinking the issue of apportionment in this country and also privacy and the right to privacy, is that not a real concern in terms of changing the rules? Because the one thing that we tend to agree on in this nation are rules and laws and that kind of focus. We don't agree on substance, but we do agree on the rules. So isn't he focusing in terms of raising that agenda towards a change of the rules?
I think from a political perspective, the issues that are raised by his nomination are very important to the future of our country. On the other hand, these are not necessarily new issues. A lot of these are old issues. For example, his perspective of, or his concept of judicial restraint and the idea that he proposes the idea that we're supposed to go back and look at the original intent of the drafters of the Constitution and interpreting the Constitution are certainly not ideas that he thought of in the first place. I think he is taking the position that we ought to go back and re-examine some of those decisions that have been made in recent years, and certainly not creating anything from whole cloth. I'm not saying that I agree with a lot of his positions, and I certainly don't agree with a lot of his positions, but the fact is that he's not any kind of a new thinker as far as these kinds of approaches to the Constitution. They've been debated probably for the whole 200 years that the Constitution's been in existence.
I believe, though, what you have to look at, when John, you mentioned the White nomination, the Berger nomination, the nomination of Brennan, was that none of these people really had such a track record of stating their positions as Justice Bork. And indeed, those three people are really exceptions. If you go through the list of presidential appointments, those are the ones that stick out. But most times presidents are pretty accurate in choosing the kind of people that they want. But much of the trouble that Bork is in today, I think, came from a game plan that he originated way back before he was nominated to be Solicitor General of the United States, and that was, I'm going to get my name out in front. I'd like to serve on the United States Supreme Court. And there was an advantage and disadvantage. He became very well known, got on the lecture circuit, wrote law review articles, and now he has a record he has to defend. And I think that's his strength and his weakness, and I think that's what we'll see developing in the next few weeks.
Does he have a label? As the hearings began this week, he denied that he could be pigeonholed as a conservative or a liberal. Does he have a label?
Well, certainly if you look at the kinds of cases that he has decided and the positions that he has taken, it's certainly in a conservative direction. Anti-individual rights, pro-business, I would say that would pretty much define him, even though these are labels that sometimes we get a little uncomfortable with because of simplification. Certainly you could put him on the conservative side. He's a judicial activist with a conservative bent, which would make him different than a Justice Warren or Justice Douglas, who were judicial activists in a liberal direction.
I think you have to ask the question, liberal in terms of what? Liberal and conservative mean many things to so many people. Let's take the issue of conservative, liberal as far as government is concerned. When it comes to the issue of the executive and the Congress, he seems to favor the executive over the Congress. That might make him a conservative in the sense of supporting authoritarian power. When it comes to the issue in terms of the relationship between the individual and government, he tends to also favor the state. So in that sense, he would also be a conservative in the sense that he favors an authoritarian way of government. On the other hand, if he says that the state should not be involved in certain kinds of issues, he would be viewed as a conservative. So it all depends how you look at it.
You can play around with labels and sometimes not come up with any kind of a meaningful discussion. I think he described himself as a libertarian back in the early 1960s when he took some positions that aren't particularly popular today on civil rights issues. I think his approaches or his attitudes, like all of ours, have evolved over the years, and of course he has, as Ralph said, he has one problem, and that is that he's been very prolific in his writing and in his speeches, and being a professor, as two of you gentlemen are, you know that professors tend to write and speak more than the population as a whole, and I suspect that there are some things that you have said or written over the years where you have changed your attitude. For example, I think Bork was originally an Adlai Stevenson supporter, if I remember correctly, and perhaps changed his political outlook when he went to the University of Chicago and University of Chicago Law School. But I'm not sure that we can say right now exactly how Judge Bork would decide a particular case. Even the abortion case, he denies that he's made up his mind on whether Roe versus Wade should be overturned.
But as I understand the issue on the abortion case taken from the Griswold case of 1965, where he says there are real limits as far as privacy is concerned, and so therefore a woman's right to privacy by implication is also limited. Is that his kind of thinking?
I think he said that that the decision that was handed down by the court was not the result of what he viewed as a very intellectual approach to the right of privacy issue. What he had indicated was that in reviewing that case, if it's presented to him, I need to emphasize that, if case isn't presented to him, then he and the other 8 justices can't just go off and make a decision on this point. But assuming that he has an opportunity, he and the other 8 justices, to review that, then he'd indicated that he would review it in the sense of trying to find out if there's any way to uphold that decision, because he does believe in the doctrine of stare decisis, which means that if possible, you try to have some continuity in what the law is and uphold previous decisions. And if he can do that consistent with his approach to constitutional interpretation, then he would do that.
Some months ago on this program, when we discussed the elevation of William Rehnquist to Chief Justice and the nomination of Scalia to the vacancy on the court, I expressed as a journalist some concerns about their stance on free press. And I was told by our expert on press law at that time that don't be so concerned about that, because regardless of what their records were, as Scalia in this case, as a federal judge, once they get on the Supreme Court, there's something of a change of attitude, a change of posture. They're not so high profile. They tend to blend in with the pack, and while they might stray occasionally, that in fact they become a different kind of person, a different kind of justice. True or not?
Well, again, it depends, I think, Larry, on the context and the situation. He's going into a very fluid, dynamic situation, and he's someone that keeps being told that he's the finest nominee for the Supreme Court in terms of intellect for 50 years, so I don't think he'll be a shrinking violet. And as John has said, you never know precisely what a person will do once they get on the court, but I think you have a better idea what Robert Bork will do in the court than almost any nominee we've had in the last 50 years.
And you don't count on the fact that he's all of a sudden become the shrinking violet on the court, huh?
No.
I don't think he will either, but I also don't think that just because he becomes Justice Bork that the other 8 justices are going to turn and say, well, what does Justice Bork think on this? Maybe this is what the position of we Reagan appointees ought to be on this. That isn't the way the Supreme Court works. These are all people of intellect and all people with their own egos and with their own opinions, and certainly even the appointees that have come so far from President Reagan have not followed, much to the chagrin of a lot of conservatives, have not followed the traditional, what you consider the Reagan conservative line.
Isn't, if I can get back to the issue of the proper role of the court, isn't this a situation kind of a commentary on the fact that the politicians in this country, both at the state and national level, are reluctant to get into very difficult, controversial issues because they're going to lose politically, and they've left it up to the courts to get into the thickets of abortion or affirmative action or school prayer, and the politicians, if they take sides on these issues, they're going to lose. Isn't this kind of a commentary upon the elected branches of government as well?
You bet. You bet. I mean, that's what the court has been about for the last 50 years, is dealing in the areas of individual rights, and I think the civil rights movement is probably the best example. And earlier, John, you said that this is sort of an analysis of the popular representative branches versus the court, the non-democratic. But if you look at the politically weak and powerless, where have they turned in the last 50 years for help? Has it been the White House? Has it been Congress? No, by and large, it's been the Supreme Court of the United States. So we're talking about labels, and it's very difficult sometimes to get into that. Judge Bork does not support legislation which limits contributions that one makes to campaigns, and he bases that on the First Amendment. He has a limited interpretation of what free speech is, but it includes making large contributions to campaigns. What does that do in reality? It means if you cannot afford to give large campaigns, you may not have a great campaign contributions. You may not have a strong voice with that candidate. So where are you going to turn? And you're going to turn to the quote, unquote, non-democratic institution. And so I think that's been a very important role of the court, and one that Judge Bork overlooks.
Also, as we look at the three branches, the executive, of course, reflects the views of the majority. So does the Congress. And so the issue in terms of philosophy is who is going to protect the minority. The infamous exclusionary rule is up for reconsideration as well. In terms of the very essence of our society, we have the abstract phrase of majority rule, minority rights. Well, that's abstract to very many people. Let's give an illustration of that. If a person would be despicable enough to assassinate the president, that person would be assassinating the representative leader of the majority. At the same time, the person who is so accused is guaranteed certain rights. So in that sense, even the person who has been accused of such a despicable act has certain rights under our society. And as you look at the three branches, you have to ask who is going to protect those people who are in the minority, and that person so accused would of course be in the minority. So if you have all three branches reflecting the views of the majority, who's going to step in to protect the minority?
The important distinction there, though, is that Justice Bork has a different point of view. Judge Bork, at this point, has a different point of view on what rights an individual has, perhaps, than his opponents do. And just to give an example of the exclusionary rule, presumably from his writings, Judge Bork believes or doesn't believe that the Constitution provides a basis for an individual to avoid a conviction by not having evidence admitted because it was obtained illegally, whereas his opponents on that issue feel otherwise. So it's a perception of what rights exist under the Constitution, not whether or not an individual has rights. In other words, presumably there is an area, but a more limited area, in which Judge Bork would feel that individual rights of the minorities must be protected against the tyranny of the majority. The thing that I think is important to emphasize about the Judge Bork nomination is that it's really a new approach to how we look at whether or not a justice or a person is qualified to serve on the Supreme Court. To the best of my knowledge, we've never had a situation where the primary issue as to whether or not a person is qualified to serve on the court is what point of view does he have on certain political issues, issues that are controversial right now. The decision in the past has always been made on the basis, is the person qualified intellectually, by character, by integrity, and without getting into, to any great extent at least, what political positions a person has held. So this is a major shift from the past.
I would disagree.
Yes, go ahead, Ralph. You have the first.
I was just going to say that there have been instances like Brandeis was questioned very tough because of his point of view. Parker was and actually defeated. But the question here is no one's ever said the president can't look at ideology. The president tends to look at character, professional skills, which Bork certainly has a fantastic resume in that sense. They also look at representational factors, like is he a Republican if you're a Republican president. And then also ideology has been important. And if presidents can do it, and the Constitution says advise and consent is the role of the Senate, then certainly the Senate can do it. And I think if I were arguing for the Bork nomination, which I obviously up to this point doesn't look like I am, the strongest argument I think that the other side has would be the one that you're making, John. But I think it's lost because I was interested in looking at a public opinion poll that said that the American public, 50% to 40%, agreed that the Senate can decide this issue on the basis of what his positions are. So this is the argument I would make the very arguments you're making, but I think even the Republicans on the committee are losing that at this point.
I'm not saying that the Senate can't do that because the Constitution really doesn't say a thing about that issue. It just says advise and consent. The appointment is the president's appointment. It's not the Senate's appointment. The Senate advises and consents. I'll go back to my original position because I don't agree with you that any other justices have been held off, or nominees have been held off the court on account of political beliefs. Brandeis was, in fact, selected to serve on the court and went on to become one of our greatest justices on the court. But subsequent to that time, to the best of my recollection, the only two nominees that have been turned down have been Clement Haynesworth and Harold Carswell.
Well, but Johnny, if you go back to 1969, Lyndon Johnson was leaving office. He tried to appoint Abe Fortas, and there was a lot of politics involved there. I mean, see, the controversy and the politics is set up by that document of 200 years ago, and I don't see the problem as long as Bork has raised all these controversial issues of the base of how things should be decided in society, the rules. I mean, he is questioning the, in terms of the way I look at it, the rules. He's raised all those issues that focus upon the role of the individual in the state. And that gets down to ideology about how, what we think that the police ought to do and the state ought to do in so many facets of life. And I think that is a legitimate concern that people have. And I do not think the Democrats are off on a witch hunt, as William Safire implies.
Now, let me respond to that. I think Senator Kennedy, Ted Kennedy, before anything really came out in any detail about what Bork's background was, or about any studies in terms of his writings and such, came out with a statement that was extreme in the sense that it said that from his perspective, if Bork was nominated, we would go back to pre-1954 where we had segregated schools and individual rights and liberties would be totally out the window. And I think some other groups have called Bork a Neanderthal man. And really, in the record, there's nothing to support those kinds of extreme attacks on his integrity. I think it's proper to question and to investigate into his perspectives on some of these issues or his points of view. What I'm saying is that I personally, from my background, would not think it appropriate to vote up or down on his nomination just based solely on how he stands, for example, on abortion, which is a very controversial issue in which I believe some senators have indicated that whatever he stands on, that's how I'm going to vote. And so I think that you need to look at these traditional issues of intellect, integrity, character, and even though I don't agree with him on a lot of political issues, I would think that he ought to be nominated, as did President Carter's lawyer, Lloyd Cutler, supports his nomination 100%.
I think the Senate, though, can go beyond an investigation of whether there's a fool that's been nominated or a scoundrel. And certainly, ideology is not always mentioned as you go back through the history of these confirmations, but it's obviously there. If you look at, as political scientists do, when do people get defeated when they've been nominated for the court? There are two factors. What is the party of the president, and is the same party in control of the Senate? That's one important factor. That's where you're likely to have a defeat. Of course, we have that today. The other major factor is the timing of the nomination. If it's in the last year of a president's second term, then there's a greater likelihood of defeat. Of course, this time we're in the third year of President Reagan's second term. So politics is very much a part of this. We're talking about the clout of the president. We're talking about party lines, of which there's a large mixing of ideology and party lines.
But this is very recent. I was reading an article in the National Law Journal the other day that said until 1925, no nominee had ever appeared before the Senate Judiciary Committee to be questioned about his character,
That's
etc.
true, but
Justice Stone was the first one. The second one was Frankfurter in 1939, and Frankfurter said he thought it was really in bad taste that they called him in front of the committee. And then the third situation they pointed out was when our own Indiana Justice Sherman Minton was appointed to the court, he said, "I'm not going to appear. I stand on my record, and it's up to you to vote." So,
but isn't this very healthy? I mean, the fact that we can be educated by watching these hearings and the public can become involved, because what Bork is doing, as I implied, raising an agenda. So at some point in the process, the truth will get sorted out.
And let's not mix the hearings with the conflict. 20 of the first 81 nominees to the Supreme Court were defeated. They were not confirmed by the Senate. There were no hearings, but there was partisan battles, there were squabbles, ideological problems. There's been a much better record. That's why we look at the unusual case now. In this century, we've had very few defeats. We've had 3. This may be 4. But so that's where the differences are. Of course, Fortas was a defeat, too.
John, you made a good point, and that is that one of the outstanding things about these hearings are that it's focusing, hopefully, the public's interest. I'm not sure if a lot of the public really knows what's going on, but hopefully it's focusing a reasonable percentage of the public's interest in the Constitution, what it stands for, and the fact that there are different ways to interpret the Constitution. For that matter, how important the Constitution and the Bill of Rights are to our individual freedoms. So in that sense, this is just a great thing to happen. Really great to have it happen at the 200th anniversary of the Constitution.
An educational process on the process. But then, of course, on the committee, televised hearings, you have Joe Biden, chairman, who is running for president, Ted Kennedy, who has run for president. Are we going to learn something from these hearings, from the television?
Oh, I think you'll learn something about, as John just said, about the Constitution, about Bork's point of view. But it's always been, the Supreme Court's always been right in the middle of politics. There's no way to get around that. Just on the Biden issue, I think that Biden cannot win on this. I don't think it's going to help his presidential aspirations at all, win or lose. If
I can take the conversation down to Indiana.
For 30 seconds.
In 30 seconds? The question would have been, if I'd had, if we'd had the time, what impact does this have upon Indiana? The sure thing we can say is that the controversial commentary by Justice Bork was in the 1971 Indiana Law Journal. So as we conclude this program, we know it all really began here in Indiana.
We started with William Bruckelshaus, and then we end with that. We've got the Indiana connection. Thank you very much. We're out of time. Thanks to our panelists, Ralph Baker from Political Science, John Mulla, Muncie attorney, and John Rouse, our executive producer. I'm Larry Lough. Thank you for joining us.
If you have comments regarding this program, please address them to John Rouse, Box 149, Muncie, Indiana, 47305. The producer for Public Affairs Roundtable is John Rouse. Associate producers are Bill Mosier and Mike Seaborg. This program is a production of University Media Services, the Department of Political Science, and radio and television stations on the campus of Ball State University in Muncie, Indiana.